Okay, Assalamualaikum warahmatullahi wabarakatuh and good evening to our honourable speaker, Miss Victoria Chee, my group mates and audiences. Welcome to today's program, Mediation in Family Matters, Custody, Maintenance and Matrimonial Property. I would like to thank everyone for taking the time to be with us here on this lovely evening. My name is Nur Sofia Maisarah binti Nordin and with me is Nurul Amira binti Muhammad Zaidi. So we will be the moderator for today's discussion. So today's program will begin with a short introduction about our speaker and also we will briefly introduce what is mediation. And after that, we will continue with a sharing session by Miss Victoria Chee, then followed up with several questions that have been prepared by us. So right now, I will begin with the introduction of our speaker. Miss Victoria Chee is a mediator on the panel of Bar Council Malaysian Mediation Centre and Mediation Centre Sabah. She has vast experience in mediation, especially in family matters. Her reputation for handling sensitive family corporate disputes, coupled with her mediation skills and business acumen, has seen her successfully manage cross-border corporate disputes for multinational companies involving different jurisdictions with multi-million dollar transactions negotiated. For her legal background, Victoria's practice has now crossed international borders and she is currently handling legal matters for various multinational corporations in Singapore, Taiwan, the Philippines, and more. Most importantly, she also gives back to the community by being involved in charity organizations. She is currently the legal advisor to Sabah Pangolin Sanctuary and Research Institute, also known as Sabsari, and consistently undertakes legal pro bono work for Taiwan Buddhist Tzu Chi Foundation, Malaysia.
Next, I will briefly state what is mediation. Mediation is a process where the parties settle their disputes with the assistance of a certified mediator who assists them in reaching a settlement or agreement. The disputes may be cases that are pending in the court or potentially be a cases or dispute that can be filed in the court if the mediation does not work. Cases that are suitable for the mediation are disputes in commercial transactions, personal injury, family matters, and many more. Without further ado, we will start our first session now. I would like to invite Miss Victoria Chee to share with us about the nature and process of family mediation. Let's welcome Miss Victoria Chee.
Hi everyone. Okay, so today there are two topics that I've been asked to talk about. Number one is the nature and process of family mediation process. Okay, and also the challenges and reasons why mediation is better than court litigation in solving family disputes. Okay, so let's talk about the nature and the process. So nature. What is important about mediation is that it is supposed to be flexible. So I think that's the main nature that's there to help parties solve the dispute. Okay, so you are not restricted by a court system, a court structure to get to the outcome that parties are trying to resolve. So, then of course, succumbing to submitting yourself to mediation, it's confidential and of course it's privileged. So having those rules governing the process, it basically gives the comfort for parties to be really open about the problems they have. Because when you go for mediation, there's a dispute, and most important is to solve the dispute. Okay, so process also very flexible. But when, for example, you are training to be a mediator, they normally teach you to do it in 5 stages. Okay, so number 1, you have the preparation stage. Then you have the opening stage, exploration, that's number 3. Number 4, negotiation. Number 5, closing. Okay, So even when we talk about mediation, there are a few methods and models of doing it. Like, for example, there are settlement mediation, where parties and the mediator are very focused on just settling. Okay, so when we do settlement mediation, basically we encourage bargaining towards a compromise. So you move toward the central point. So each party will see the central point, then where you can get a compromise where you settle. That's number one. Then you have transformative where parties and the mediator will be focusing on empowerment and recognition. Okay, so the aim is to take their own decision and to take their own action, where you foster and actually develop recognition for and between parties. Highly parties. So this transformative mediation, where parties are actually very and tell. Okay, you want them to tell their story, and you want them to also hear the other party. So also very helpful and useful in family disputes, because sometimes, and actually most of the time, people want to, for example, get divorced because they don't communicate anymore. So you submit yourself into mediation, and then the mediator, for example, if you're using this model, narrative mediation, you basically encourage them to talk, okay, to talk and to listen. And there's another kind of mediation called evaluative mediation. That's where parties and mediators will work together to try to reach a settlement according to the legal rights of parties and within an anticipated range of. So this is more guided by the mediator's expertise. In family-related mediation, we can use this when parties are already in court, when they are already involved in, for example, litigation. So a mediator can work with their lawyers to say, oh, you know, this is a possible outcome that the court may give. So you might want to think about it, and you may want to compromise on certain issues. Okay, so obviously when we talk about custody, maintenance, and matrimonial property, we are guided by the law. Okay, so these are the few models of mediation which the mediators could use when helping parties. So when you're talking about the process, when we go back, you basically can mix and match. That's why I say the main nature, if you ask me, is flexibility. Because, like, for example, as a mediator, I can go in starting with narrative mediation. I can encourage to talk. You know, they talk, they argue, they bang table, they throw things, and you know, when the emotion is when they have already said their side of the stories, then you guide them using the few model. You can be very flexible. At the end of the day, it's really just being another human being, you know, sitting in front of these parties and trying to help them to reach a decision themselves. Because one of the most important characteristic of mediation is that you cannot impose a decision on these parties. You have to help them, assist them to get to wherever they want to or they are willing to go to. So it's not like, for example, arbitration. It's not like, for example, in court where, you know, the court or the arbitrator will impose a decision on parties. Mediation is really to help them, to facilitate the negotiation, the settlement. So even, for example, if you go through mediation final stage where parties are able to settle, to me, I think that's okay also, because sometimes time to smoothen the process. So they might go through, 2, 3 mediations, they don't get there, but probably the 4th, 5th time they could get there. Okay, so but it always helps. So like for example, during this COVID era, even the government is very to submit out, because if a dispute is, for example, managed by a very skilled mediator, normally parties would see that this is a very, very useful process to solve their problems and conflicts. Okay. So this is the first part. I'm not too sure whether you guys want me to do the second part, or we do Q&A, or how do I continue with the challenges and reasons?
No, we will proceed with the Q&A session first.
Okay.
Yeah. Okay, so thank you, Miss Victoria, for the insightful discussion. So from your sharing, we now get a clearer picture and actually known about the stages of mediation and so the nature of the process as well. So due to this, next we will move into the Q&A session. We actually has prepared a few questions to be asked to Miss Victoria. So for the first question is that, as a mediator, how do you assist the clients in making agreements for family matters between the parties?
Okay. So for this question, basically, number one, you have to be quite skilled yourself. Okay, so going back to the 5 stages that I've mentioned before. Okay, so for example, preparation, opening, exploration, negotiation, and closing. You are flexible to do it whatever your way, but it's quite useful to follow these stages. So for example, how do you help them, assist them? How do you assist them? So during preparation stage, okay, it's very important. For example, if there are papers, if there are documents, as a mediator, you must go through them. So for example, if in a custody dispute, and if it's parents fighting over where, so you have like paper trail of WhatsApp messages. If parties submit those documents to you, then as a mediator, you have to go through the documents. So from those documents, you are able to then identify the issues, the emotions between parties. Okay, so read the papers. Always do that if you have documents. Okay. Then when for example, if sometimes you have a preliminary conference before the proper mediation, that's where you parties for the first time, you need to see
I'm sorry.
the
I'm
person's.
sorry to interrupt you, Miss Victoria, but it seems that the line is there is interaction between your explanation just now. So can you yeah, I'm sorry. I mean, like after you talk about when you answering the first question, it's quite lagging.
Oh, yeah.
Yeah.
How about now?
Okay. Yes, we can. We can hear it.
Okay. So you got me when I was talking about reading the papers, right?
Yeah.
Okay. So for example, I was talking about preliminary conference. So when you have a preliminary conference before the mediation proper, you meet the parties. Then when you meet the parties, you want to talk to them to kind of understand how they are like, their attitude, their character, why they are in this dispute, why are they fighting with the other party. Like for example, in family matters, normally it's not just, for example, the husband and wife. Sometimes it's really not just about husband and wife and the children. Sometimes it's more than that. Like for example, the in-laws or probably a third party. So you would want to get as much as you can from talking to parties. Okay, and you can do then of course very important, you want to check whether they are really willing to go through mediation, because sometimes people go into mediation not knowing why and not knowing how the process could help them. So in order to really help them go through this process is to make them understand, how this process could help them if they really submit themselves to the process. Okay, they have to trust the process. They have to put the trust in the process, in the mediator, and to wholeheartedly do it. Okay, so that's basically assisting them, prepping them to trust the process, because sometimes, for example, if people who like to fight, or sometimes if the wife is being betrayed and she has a lot of cooked up anger and frustration and she just wants to go to court and fight it out, okay, not thinking what would the court process do to her and the family. So that's when, as the mediator, explain the process to them, explain the pros to them, so they could basically, do it. So that's quite important, making them understand, encouraging them to really trust themselves and also the mediator. Okay, and timing is also very important. For example, during the preparation stage, you need to agree on a timetable and a venue. Okay, so why do I say timing is very important? So for example, if you know that parties are already in court, fighting each other, going through litigation process, the timing is very important, because sometimes you don't want them to already having subject to cross-examination, for example. There would an angry position, because cross-examination, subjecting yourself to cross-examination is never, so you probably want to do it before that. Okay, so timing also very must see the different possible future events that's going to happen when you set the timetable. Okay, so to me, as the mediator, how do you assist the client is really to encourage them and make them understand. And of course, having, when you are being trained to be as a mediator, the skills that you learn, you just have to remember those. How do you conduct yourself during a mediation, using very neutral language, all of those things. Focusing on the clients is really making them understand and encourage them to do so.
Thank you, Miss Victoria, for the clarification. So we actually have 3 questions. So for the second question, we would like to ask you if there any difference if there are children involved in the mediation process. For instance, in cases the children are minor, so the mediator will have a separate session with the child, or we will combine?
Again, very flexible. Okay, so for mediation that involves children, very important to know that, for example, if this dispute is in court, what's the test that the judge would take is whether the child is of an age to express his or her opinion. Okay, whether the child is old enough, for example, to give an independent opinion. So the child can be as young as 4 years old, but if the judge thinks that, this child is able to say yes or no, like or don't like, then the judge, okay? So in mediation, it's the same kind of logic, okay? When, for example, you know that you are dealing with a mediation that involves children, for example, in their teenage years, or for example 13 to 16, then you know that they're old enough. You might even ask them to join the mediation, just to see how they react. But of course, it's very, very important to then, if for example if you ask the children to join the mediation, but that's just going to put them in a very awkward position, then you would do a private session. So again, very, very flexible. It's really up to the children, up to whether the mediator, him or herself, think whether the child or the children are going to help the process. So for example, if it's about if the core problem is about access, okay, to either parent, probably you could just ask, whether the child wants to see or meet the other parent. It could be as simple as that. But for example, if we are fighting about custody, or rather whether if, for example, there are accusation of domestic violence or sexual misconduct against either parent, then probably you don't want to involve the child. Or if you want to involve the child, you want to only do private session. So it's really up to the dispute. Okay, so my answer would be flexible, and then see what kind of dispute and the child's capability of actually giving an opinion.
Yeah, so like is that it depends on the circumstances, and it
Yeah,
doesn't
that's right.
necessarily to do a separate session.
Yeah. So for example, if there are accusation of domestic violence, then if it's very, very obvious that, if I put the child and one of the parents in the room and the child just shuts down, okay, that's also a very showing sign. Then something must be wrong, or something's not right. Then from that reaction, you get to see. So probably you would then not put them in a joint session. You want to put them in private session. Then you listen to what the issues are.
Then is it so that's the moment they enter the room, then the matter must observe how their character. Yeah.
Yeah. So as a mediator, it's very, very important to be very, very alert with the parties' human like body language, the language that they use, their eye contact. So as the mediator yourself, you have to be very neutral. You have to be open. So like you can't be like crossing your arms, for example, and be judgmental. So you as the mediator, because you are there to facilitate, so you're supposed to be like open. When you observe them, you will then know like what's the dynamic like between parties. So for example, there are sometimes that you will see an imbalance of power. So for example, if it's in a family dispute, probably the husband is the one who is the breadwinner. Okay, you have the wife who is a housewife, who is not financially earning but just working at home, and she might to then say, I'm going to leave this marriage because you are not very nice to me, for example. So you would need to see that, and you will need to be quite clever with the questioning. So they are, like for example, for the wife, so she is comfortable of telling you the problems. Then you see where you can come in to, try to solve the dispute.
Okay, thank you, Ms. V, for a very lengthy and also very thoroughly explanation. And for the last question, for our first session is that in conducting the mediation, so if the parties disagree to have a meeting in presence of each other, so is it allowable to conduct the session separately, or they must sit in the room together?
Again, very, very flexible. Okay, but what is important here is that to the
Sorry, Ms.
mediation profile mediate. The other says,
Sorry,
hello?
Miss Victoria.
Yeah.
Yeah, I mean, like, there is some interruption. So can
Oh,
you, yeah, can you repeat the
okay.
answer?
Yeah. Okay. So again, flexible, but very, very important is parties are willing to submit themselves to the mediation process. So if you have two parties fighting, one say I want to go for mediation, the other one says no, I want to go to court, then cannot, tak boleh. Okay, you just cannot go for mediation because parties have to do this together. But for example, if they say, I want to do mediation, but I just don't want to be in the same room with this person. Okay, if that's the scenario that we're facing, then I think the mediator can be quite creative with how it can be done. Okay, so for example, they can, do it through Zoom. The mediator can use two screens so the other person doesn't see the other person, but they could see the mediator. I've done it before. They just couldn't stand being in the same room as the other person, but they just want to solve the problem. So you have that conflicting needs. You want to solve the problem, but you don't want to be in the same room as the other person. Okay,
Yeah,
so yeah, it's really up to you to be flexible. Or for example, in a family dispute, you might be really scared about the other person, for example, hitting you or like threatening you. So you say, oh, I want to get this sorted out, but I just don't want to be in the same room. Okay. So it's up to the mediator. I think it can be done. I've done it before. But it's how you really when you are helping them, when you're facilitating that, you must be neutral and you must be seen to be neutral, because if it's in this situation, the parties are not able to see you with the other person. So the other person, for example, if you are dealing with a paranoid person and say, oh, this person might have like bribed the mediator, making different accusation. So you don't want that. You want to be able to make them trust you enough to bring the messages to each other. Okay, so like for example, in a normal mediation where parties are okay, what we'll normally do is we will start with where I talk about opening statement. Okay, that will be a joint session. Mediator will give an opening statement to both parties being in the same room. Then they will talk about their problems together so everyone could hear each other. Then we go for private session. Then we do another joint session. Then we close. But for example, your question, if they just cannot be in the same room, then you have to be creative. So like I said, probably two screens, or probably you have two mediators, because in a mediation, you can have more than one mediator. You can have two, you can have three. So you can work with your co-mediator. Okay, so probably I will just meet with the husband. My co-mediator will meet with the wife. Okay, so you just have to be creative. But as long as they are agreeable to submit themselves to the mediation process, it can be done. Okay?
thank you. Yeah. So yeah, we really understand about that. And it also answer our curiosity. So
Yeah.
thank you, Ms. Victoria Chee, for the clarification. So this marks the end of our first session for our discussion. So we will continue our session shortly. Maybe a 1 minute break for you to drink some
Okay.
water. Yeah.
So we will now proceed with the second session. Miss Victoria Chee will be presenting about the challenges and the reasons on why mediation is better than court litigation in solving family disputes. Please welcome Miss Victoria Chee.
So on the reasons why mediation is better than court litigation in solving family challenges, I would put it to three challenges. Number one, the skill of mediators that are now in the market. Okay, skills of the mediators, practitioners meaning, of course, we are talking about disputes that are already in court or nearing the court process. Okay, so skill of the mediators. When, for example, the dispute is already in court, the court still encourage parties to go for mediation. So normally the mediators that do these cases are mediators appointed by the court, who are normally registrars and judges. And sometimes they are not properly trained to conduct mediation because they are so used to being in the position where they, listen to facts, evaluate evidence, and they judge. Okay, because as a mediator, you are not there to judge, you are not there to impose a decision. So sometimes it's very difficult for them to make that switch. Okay, so for example, in a mediation where, for example, parties are screaming their head at each other, sometimes the registrar and judges, they get like very irritated, and but sometimes, like for example, if you're using narrative mediation, you would want parties to actually shout at each other because there's so much like cooked up anger and frustration, and for them to move past that stage, sometimes you just need to go through that stage, the screaming part, because that's where some people get closure. So if, for example, the mediators that are handling these cases, they are not used to this kind of scenario, and sometimes they don't think it's necessary, they themselves, as the mediators, might be a major block, okay, of parties actually moving forward in the process. So the skill set, being a mediator, you have to be flexible, you have to be able to make that switch. So sometimes, even as a practitioner, as a lawyer, when, for example, I'm doing mediation, it's actually very, it's a very intentional switch that I have to do, because as a lawyer, I'm very, very used to giving advice, so you always only take that one position, because in court you want to use that one position to win your case. Okay, but in mediation, it's a win-win situation, or sometimes we call it the win-some situation. You don't win all, you don't lose all as well. Okay, so you have to be able to see that, to understand that, and to feel that. So for example, if you are the mediator and you would already be biased in your head because you agree with the one person's position, and you are using that person's position to force the other person to settle, that's not right. And it will eventually, fail. So skill of the mediator is very, very important. So if, for example, the mediator is not able to make that switch, not understand what mediation process is, then it would fail. Like for example, I have this a personal experience where I was representing the husband in a family dispute. The husband was actually suffering from depression. So he was actually very, very worried and scared about going to court to give evidence, and even to go through mediation, because mediation was in court. So before we started the mediation proper, I actually informed the mediator that, my client, he's suffering from depression, so just please be gentle to him, okay? But the mediator during the mediation actually took this point and wanted to force my client to not to settle, so he, didn't need to go to court. So the media actually said, oh, you have depression, you're already feeling very, very stressed, right? So can you imagine if you're in court giving evidence, how stressed would you be? The mediator actually said that to the client who is experiencing depression and anxiety. So it is a good point to always remind people that, oh, you go to court, you have to subject this, but how you tell that, how you present that message is very important. So you cannot just say that to a person who is already very, very scared of the court process. Okay, so that's the mediator not being able to switch from her position as a registrar to a mediator, because as a registrar, she has her KPI as well to say that, oh, I want to clear off cases because the court is now encouraging cases to go through mediation so they settle. And trial. So she wasn't able to make that switch. So she has her own authority. She thought that she could bully, so she decided to use. Obviously, it didn't succeed because the issue that they were discussing was about custody and access of the children. So no matter how stressed and how depressed the person is, children are very, very important subject matters. Not because I'm depressed, I don't want to go to court, I'm going to give up, forfeit all my rights as a father, for example. So skill of mediator, this is a very, very good example. So whoever who is trained as a mediator, because even like especially in Malaysia, you don't really get like specialized or specialist mediators. So you're either a lawyer who's trained as a mediator, you're a registrar who's trained as a mediator, you're a judge who's trained as a mediator. So you're always in that position where you have to be intentional about the role that you're playing. So for example, sometimes when I'm in a mediation, but I'm not a mediator, I'm a counsel for a party who is going through mediation. So different. So, but the person who mediator must remember and be very, because if not, it's just going to be, to help people. You make the problem even bigger. So for that particular case that I spoke about earlier, we actually went through trial and finished the trial because mediation just didn't work after that session with that mediator. Okay, so another very, very big challenge in mediation is willingness of parties. Okay, so like I said earlier, very, very important to know that parties are willing to submit to mediation process. Okay, so for example, if you are faced with a party who is skeptical, who is not very willing to do it, then as a mediator, it's very important for you to then make them to let them know why you want to go through mediation. So it's still going back, it's making them understand and encourage them. Very, very and probably that person just want to expose, just want to expose the wrongs that the other person has allegedly. Okay, so then you will know, or for example, okay, this is the emotion that I'm dealing with. Then I might want to switch to, I want to focus on using narrative mediation. Let them speak their story. Let them tell their story, because the mediator is also another listener. Okay, and then sometimes in a family dispute, sometimes because there's a lack of communication that causes the breakdown of the marriage, and then for them to settle whatever is still there, like maintenance issue of like, or the matrimonial properties, probably the person just want to be able to say, how upset she was when she was in a marriage. Her expectation wasn't met because this. So probably giving an avenue to speak their story. Okay, so it goes back to the willingness of parties. So for example, if you have someone is very unwilling to go through, you would want to, like I say, make them understand, encourage them. So encourage them. Sometimes you want to give them what they want and need. Okay, so for example, if they know, like for example, what I want and need is to tell my story, then you will make mediation the platform for them to do that. Or for example, if someone is being abused at home, but is very raised, okay, then you as the mediator being there also gives that person courage, to bring up. So for example, when you go through mediation, you are able to convince and make them trust the process. Once they open up, once they are truly willing to do it, then that challenge will disappear and it will be a very effective mediation. You don't settle. You just open up blockages which help parties. Okay, so willingness of parties. So as a mediator, it's very, very important to also observe and to know whether they are willing or not. So sometimes if you know that this party is not willing, and no matter what you do, it's still that unwillingness that's prevailing, then probably you can just say, okay, I'm not going to waste anyone's time anymore. We put a stop to it. Some people are just stubborn that way. So it's for you to also, because you don't want to give the other person as well if it's never going to end. Okay? So that's willing. Then the third challenge is willingness of practitioners to me. So for example, if you're already in court, okay, and you know that, for example, one of the parties is represented by someone who just likes to pay, probably for very selfish reasons, because lawyers earn bigger fees if the case go to trial and go through that court system. Okay, so when you have someone represented by counsel who is like that, then as the mediator, you have to be quite creative as well. Okay. Mediation, you can always have private sessions with the parties. Then you might not want counsel to be in the room with you, because sometimes they would just say, counsel, don't come in. I want to talk to parties. So it's up to you also. But sometimes if you know that, for example, this lawyer is very pro mediation, but you have an unwilling party, so you want to work together with the lawyer to help the process. Okay, so for example, like because of COVID, like I said earlier, the government actually encourages mediation. So for example, if you go on the Pusat Mediasi COVID-19 website, you will have like a list of law firms that would say mediation first, mediate first law firms. So if you go through the list, then you will know, these are the firms, or these are the lawyers that believe in the process. So their aim is to help parties to settle instead of fighting in court, because like some litigation lawyers, they just like fighting in court for various reasons. Okay, and then so these are the three challenges which I think are the major ones. The skill of mediators, the willingness of practitioners. Whatever it is, it's for the mediator. Like for example, skill to
I'm sorry to interrupt, Miss.
How to do it and to practice.
Miss, but your internet
This
connection
more
seems
because
bit
it's more. Number one, time. Oh, can you hear me?
okay, now we can hear you. But just now
Okay.
it seems a bit.
Oh, okay. Yeah, so reasons why mediation is better than court litigation in solving family disputes. Family dispute always very emotional. Normally not like commercial where it's the value. Okay, so family a lot of emotions, a lot of stories, a lot of other reasons, a lot of parties involved. So that's number one. Just the nature of the dispute. It's just better to do it through mediation because then you can talk about your feelings. Because in court you cannot talk about your feelings. But in family dispute it's very important to talk about your feelings, like because you did not do this is not going to help you. But in mediation, whatever you want to talk about, okay, solving. Time is also very important because, like for example, children, how many years do they have to be involved in the court process? For example, trial would normally take up to 3-4 years. So how do children have access? So if you go through mediation, if you're able to settle, you're able to do it quite fast. If you're willing, if you have a good mediator to do it for parties. So time cost as well. Like I say, if you can do it fast, it would be quite minimum instead of going to court because court process is expensive. Getting lawyers to fight your case in court is expensive. And flexibility.
Okay. So thank you, Miss Victoria, for such an insightful discussion. So, for the next session, we have prepared two questions for the Q&A session for the session. So, based on your explanation about the challenges in mediation, I can conclude that it is not easy to become a mediator because it requires special skills and also a lot of patience to do so. So the first question is, as a mediator, what are the challenges in conducting mediation sessions during the COVID-19 pandemic? Because as we all know, during the pandemic, everyone is being affected. And what about the mediator?
Same thing. We are affected. We are restricted to the screen, like how we are doing it now. I think it has gotten easier.
I think your internet connections is a bit lagging again, Victoria. Can you repeat the answer?
Clicking through the screen, but a very mediated, it's not I say party.
I'm sorry to interrupt your discussion, but it seems that we cannot hear you.
Hello?
Okay, now we can hear.
Oh no, it got disconnected.
Because just now we cannot hear you. So can you repeat for the question one's answer?
Okay. So, COVID-19, like I say, always back to the screen. It's easier now because I think people are just more used to speaking through this. But if you want to solve a very highly charged, like emotionally charged dispute, you want to have that face-to-face meeting. Okay, so you can have everyone in the same room and you can talk about whatever that's annoying everyone. Okay, so during COVID, that was not possible. So that was the biggest challenge. But now, after 1.5 years, almost 2 years, I think people are more used to the screen. So we are doing more Zoom mediation now, and I could see like parties are just more comfortable doing this now instead of, for example, March, April 2020, when, for example, they couldn't even like unmute themselves or connect to the audio of the Zoom app. But yeah, we're not facing that problem anymore.
Okay, so thank you, Means, for your thorough answer. So for the next question, throughout your experience as an accredited mediator, how do you handle a situation where both of the parties cannot achieve agreement until the end of the mediation session?
Until the end of the mediation session.
Yeah.
Sorry, can you repeat the question?
How do you handle a situation where both of the parties
If
cannot
they are
achieve
dissatisfied, is
agreement?
it?
Yeah.
Okay. Okay. So, if they cannot settle, it's still the mediator reminding them of at least taking the effort to try to settle. Okay, so um, agreeing to solve it through mediation and actually attending mediation, those are good signs. Okay, so normally when we do the opening statement, we normally congratulate parties for even getting to that stage, because some parties will just say no, I don't want to do it. Okay, I just want to go to court. So for parties to say yes and for parties to actually attend the mediation, those are good steps. So you just need to remind them. And even, for example, first, second mediation fail, cannot settle. You just need to remind them, encourage them, hand holding sometimes, really to say that, or like, for example, if you're in court, okay, you will probably have a trial date that's 1 year from now. So 1 year from now, you still have many opportunities to have another mediation. So just keep that opportunity and possibility open. And sometimes you would want to ask them, why do they think that they couldn't settle? So, for example, it might be the mediator. Okay? For example, one might think that, oh, this mediator biased a bit. I don't like this mediator. So change mediator. The mediator must be very aware also whether he or she is able to help parties handling for example, a custody issue. Okay, and for example, if the wife, and being the mother, she's very her main complaint, for example, is being very tired, being very exhausted. She probably have like postpartum depression. So if the mediator is a man, for example, the man may not be able to understand, okay, the feeling of, for example, breastfeeding a child, or even delivering the baby. That's not something that the mediator, if, for example, he's a man, he won't be able to understand. So probably the wife may not be comfortable enough to be at her most open state to talk about her. So the mediator have to be aware, then say, oh, probably I'm not the best person to facilitate this process. I might want to get another co-mediator, or I might want to resign from this position where parties can then get another mediator to help. Okay, so yeah, so when you are in that situation, observe and then think about
Miss
what's causing the parties to not settle. And for example,
can you repeat your conclusion for the answer, because just now we cannot really hear you.
oh, okay. Yeah. So like I say, mediation, very important to remember. Mediators not there to impose a decision on parties. Okay. So if, for example, they are not able to settle, they must know that it's their decision not to settle. So, for example, if their main aim is to settle and get this thing over and done with, for example, so because like family dispute, sometimes people just want freedom and not want to deal with the other party anymore. Okay, normally so main priorities. So they have to make them understand and check their priorities. So if they are not happy with the outcome, but not settling upsets them more, probably they want to try another session of mediating. So yeah, conclusion is making them understand and encouraging them to trust the mediation process.
I see. So thank you, Miss Victoria, for a great sharing of knowledge throughout our discussion for both sessions. So for the next session, I will pass to Sophia for a virtual photo session.
Sorry?
Can you unmute yourself, Sophia? Okay.
So, yeah, sorry. So we actually have arrived to the end of our second session. So I would like to ask everyone to be ready for a photo session, and I kindly request everyone to turn on their cameras. So Masura, are you ready? Because she is the one who will take our picture. Okay. So yeah, on my count. Okay.
Miss Victoria.
Miss Victoria, are you ready? Okay, so
Yes.
okay, so on my count, 1, 2, 3. Okay, another one for freestyle. Yeah, for freestyle. So 1, 2, 3. Okay.
Okay, so on behalf of our committee. We would like to thank our honourable guest, Miss Victoria Chee, for making time in her busy schedules to join us here this evening. And we will treasure the knowledge about the family matters, family mediation that we have received today. It was such an insightful discussion. So with that, our second session for mediation in family matters, custody, maintenance and matrimonial property has finally come to an end. Thank you so much and have a great evening, everyone. Stay safe.